EB-5 is a U.S. government immigration program that allows foreign nationals to receive permanent residency, commonly referred to as a green card, when they invest at least $800,000 in a project that creates 10 full-time jobs in the U.S. economy. There are two options for investing: direct EB-5 or through a regional center. Historically, fewer than 5% of investors choose to invest through the direct program because job creation requires creating salaried positions for 10 full-time employees. Acquiring an existing business does not usually satisfy the EB-5 requirements because existing jobs cannot be counted. More than 95% of EB-5 investors choose the regional center program. Regional centers are private companies that have a designation from the U.S. Citizenship and Immigration Services. That designation enables them to accept multiple investors into one project. Regional centers can raise funds from foreign investors, pool the capital together, and finance larger projects that create many jobs, such as construction of hotels, hospitals, infrastructure, and commercial buildings. Regional centers have a special privilege in that they can count all jobs created directly or indirectly by their project. For example, an investor makes a direct investment into a construction of a boutique hotel. The only jobs that can be counted are those of staff directly employed by the company. However, if a regional center finances construction of a hotel, the investors will get credit for the jobs created as a result of construction spending, hotel staff, and even positions created by the vendors and suppliers of the hotel. This makes it easier for the regional center projects to comply with the job creation requirements. The EB-5 investment visa program was created in the early 90s but did not become popular until after 2007, when the requirements for this program were simplified. In 2007, there were approximately 15 regional centers across the country. By 2019, they were about 1,000. In 2022, the EB-5 Regional Center program received a long-term 5-year renewal, becoming once again a popular method of seeking permanent residency in the United States. The following example illustrates a common way an EB-5 Regional Center project is financed. However, it is important to note that all projects are different and their funding structures vary significantly. In a typical EB-5 financing model, the project developer contributes approximately 20% of the project budget. These funds are often used to secure the land and to do pre-construction work. The EB-5 investors enter into a limited partnership, and this partnership makes a loan or an equity investment into the project. It usually amounts to approximately 30% of the total budget. The EB-5 loan is typically issued for 5 to 6 years and is secured by the assets of the project. The remaining 50% comes from bank financing. In this example, we would typically see that the bank is in the first lien position, EB-5 investors will have a second lien on the asset, and the developer is last in line to receive repayment of the funds. A common timeline for an EB-5 project is a 2-year construction period, followed by 3 to 4 years of operations. After that point, the developer can either sell the asset or obtain a low-interest loan to repay the EB-5 investors. The 3 main immigration steps in the EB-5 program are project selection and preparation of an I-526 petition, followed by green card processing, and finally, an I-829 petition to remove conditions. During the first step, an investor will work with an immigration attorney to prepare documents for an I-526 petition, and with an investment broker to find an EB-5 investment project. Licensed investment brokers perform their own independent due diligence on the project before presenting the options to the investors. Immigration attorneys will guide the client through the process of collecting source of funds documents. There are many different sources of funds that can be utilized for an EB-5 investment. Common examples include income from a salary or business, inheritance, or a sale of real estate. Gift or loan receipts are also permissible under the EB-5 program, as long as the donor's or the lender's source of funds can be documented. Step 1 typically takes 1 to 3 months to complete. Once a project is selected and the investor's financial documents are ready, the investor wires the funds into the project and can file their I-526 petition with USCIS. On average, I-56 petitions can take 1 to 3 years to process. However, some investors and their immediate family members may be able to qualify for a temporary status in the United States while their I-56 petition is pending. After the I-56 petition is reviewed and approved by USCIS, the investors can proceed with Step 2, obtaining a green card. Applications for green cards can include the investor, spouse, and usually children who were under 21 years of age at the time the I-56 petition was filed. Children from prior marriages and qualifying stepchildren can also be included in the family unit. Green cards may be obtained through consular processing or through an adjustment of status in the United States. Both processes take approximately 8 to 10 months. Consular processing requires submission of investors' documents to the National Visa Center. After processing, the case is sent to a U.S. consulate abroad, where the investor and his family will go to an interview and obtain immigrant visas. The investor and his family become U.S. permanent residents when they enter the United States on their immigrant visas. Green cards are then sent to them in the mail. If the investor is in the United States at the time the I-56 petition is pending or is approved, he or she might be eligible to apply for a green card in America through a process called adjustment of status. A request to adjust status from non-immigrant to immigrant is submitted to a United States Citizenship and Immigration Services office. While awaiting the processing of the adjustment of status, the investor and his or her family may receive a temporary work and travel permit. Once the initial conditional green cards are issued, the investor is not required to take any further action for 2 years. The last step in the EB-5 process is the removal of conditions. 2 years after receiving the green card, the investor must file an I-29 petition to remove conditions. Green cards are issued based on a showing of lawful funds invested into a project that is expected to create 10 full-time jobs. The conditions of the green card are removed once the investor shows that the project was in fact built in accordance with its business plan and that the jobs were actually created. Once USCIS confirms that eligibility was met, they approve the I-29 petition and the investors receive permanent green cards. 5 years after receiving the first conditional green card, the investors are eligible to apply for U.S. citizenship. There are many nuances and intricacies in the EB-5 process. However, historically, this program has a high average approval rate. Based on government statistics, over the past few years, I-56 approval rate is approximately 85 to 90%, and I-29 petition approval rate is over 90%. Investors should ensure that they are using competent immigration attorneys and licensed investment brokers to accompany them during this process.